So we're going to be on, I'm going to make a big statement.
We don't have access.
I mean, why we're here.
What are you looking at?
DOC won't give it to us because.
I just want to give some history to this thing. And maybe, Jack will do it. No, we have to. We did. This is the report that started the whole thing. This is what started the whole thing. And this is what really started the whole thing. Because we wanted to have conditions.
DOC.
Is this, oh, this is on January.
This is what happened. We were going to have conditions to the variance, and they pulled the variance saying that they can report whatever they want.
Yeah, I think that.
We
they
wanted the conditions
probably
because we
have
wanted
some
institutionalized reporting of the stuff.
these things, I don't know.
They didn't want us to do
How
that.
much they're looking at.
So
We had
they
tried
said,
at one
we
point
can
to
tell
create,
that the health department, H&H can give whatever it decides is important for the security of the institution. Is that right? It doesn't matter. Just say, you're supposed to say yes as my counsel.
Let me see.
Yeah.
She's good counsel.
Yeah.
I'm not gonna do that.
Okay.
Have people submitted comments?
We have-
Correctional Health Services submitted, we'll publish that.
Last night.
We just got it, about 6 o'clock last night.
I just finished running this at 11:07 last night,
Okay.
so we're on the same page apparently. So sorry for all the waste.
All right.
Yeah.
You want me to
I
start
like this
reading?
room, I can actually
All
hear.
right.
Right for us. Mm-hmm. That's not big enough, that thing.
Good. We're going to be able to accommodate the audience today.
You know, there was a scene in Star Wars, they used Q-tips.
Yeah, I'm just going to give a bunch of background.
Yeah, that's
I'm going to
okay.
read a bunch of background information.
Okay, I just wanna make sure this is
Stanley, do you want to
actually-
say anything as well, or?
No, I think if you're gonna do the background, Bobby wants to,
He's got his statement.
yeah.
All right.
We won't be that one.
Okay, so I'm going to open it, and I'm going to recognize Bobby, and then we'll.
Have speakers.
Yeah. And should I say that we've received, I'll say that we've received a statement from New York City Health and Hospitals. Yeah. I'm good to go?
Yeah.
Okay. Good morning, and welcome to this special public hearing on the board's proposed rulemaking. The proposed rules, which have been posted publicly since May 13th, include amendments to the board's existing healthcare standards, Section 308, on patient confidentiality, as well as a new healthcare standard, Section 3-16, on injury reporting. At the outset, I would like to provide background information regarding this rulemaking and also to remind everyone of the next steps in the rulemaking process. In January of this year, the board published a report summarizing data on serious injuries to people in custody and an audit of serious injury reports. The report documented an 80% discrepancy between the number of serious injuries diagnosed by correctional health services and the number of serious injuries reported internally and publicly by the Department of Correction. Following up on these findings, the board planned to impose conditions on a longstanding variance that allowed sharing of injury information between CHS and DOC. However, just prior to the February 2019 public meeting, at which the board was to consider the variance with conditions, the law department rendered a legal opinion that the board's variance was not required. That opinion was based on a new interpretation of the minimum standard from which the variance had been sought. In February, the board unanimously approved a resolution expressing disagreement with the law department's opinion. The board also announced it would enter rulemaking to clarify the minimum standards and implement additional rules to improve injury responses and prevention. In February 2019, the board submitted draft proposed rules to the Law Department, the Mayor's Office of Operations, and to DOC and CHS for review and comment. BOC received and was responsive to all feedback. The Law Department and Mayor's Office of Operations certified the proposed rules just prior to the May public meeting, after which the board published the proposed rules to its website, shared them with interested parties, and voted at the May meeting to begin the rulemaking process under the City Administrative Procedure Act. Among other things, the proposed rules seek to expressly allow CHS to share with DOC specific diagnoses related to injuries sustained by people while in DOC custody, and address issues identified in the board's serious injury report by requiring DOC and CHS to comply with data collection and reporting requirements concerning injuries. Under the proposed amendments to Section 3-08, CHS would also be able to disclose certain communicable disease diagnoses when exposure has occurred at a facility, and it is necessary for CHS to engage in contact tracing to protect the health and safety of exposed individuals. When such disclosures are made, CHS would be required to inform the board within 24 hours. Additionally, in recognition of the fact that individuals in DOC's custody are people first and the circumstances of their incarceration is not their defining feature, the board has made a commitment to employ person-forward language in its minimum standards and general communications going forward, a commitment which is also reflected in the proposed rules. Thus, the proposed rules and the board's rulemaking efforts going forward will not refer to a person in custody as inmate. The board created posters for the jails that describe the proposed rules and opportunities for public comment. As requested, DOC posted the posters in each jail's law library, visit area, and clinic for people in custody, and in each jail's staff locker room. The full rule is also available in each jail's law library and the Office of the Deputy Warden of Administration. As noted in the poster, the board has a dedicated voicemail box that people in custody can call to comment on the proposed rule. Today, we will hear testimony from the public, and then after the hearing, we will continue to welcome written testimony by mail or email until next Tuesday, June 25th. The board will then make any necessary revisions to the proposed rules and submit final rules for certification by the Law Department and the Mayor's Office of Operations in time for a final vote by the board at its July 9th, 2019 public meeting. Under CAPA, any rules passed by the board would take effect 30 days after the board vote. Okay, we will now invite testimony from the public on any or all of the prepared rules. Speakers will be limited to 4 minutes, so please be aware of the time. Thank you. Good morning.
Morning, ma'am. How are you?
I'm well, thanks.
Okay. Morning, everybody. Martha, Bobby, Stanley. How y'all doing?
Good to see you.
Actually, I think this is the one time I'm actually going to be under 4 minutes. Dear Ms. King and Ms. Sherman, of course, I'm Elias Husamuddin. I'm the president of the Correction Officers Union, and I represent the more than 11,000 correction officers. The proposed rulemaking purportedly directed at healthcare minimum standards adversely impacts the terms and condition of employment of correction officers in consequential ways. As often happened, the board has not considered part of the mandate placed upon it to deal with the care of staff. Many of the terms of the proposed rulemaking actually do harm, whereas the Hippocratic Oath calls for the contrary. Current procedures within the Department of Corrections and indeed in facilities maintained by the New York City Health and Hospital Corporation often place city health employees in what the board's proposed rule change terms due loyalty. If a gunshot victim and alleged perpetrator are admitted to a city hospital, the healthcare professionals are obliged to report matters for forensic evaluations for criminal prosecution or investigatory purposes. Why this should be different with those in custody of the Department of Corrections, I don't know. The proposed rule change not only alters decades of practice, but likely violate laws, regulations, and straightforward medical obligations owed by those medical professions to serve all servants of the city, including law enforcement officials, their assailants, and victimizers. The proposed rule change directly harms correction officers in regards to the prohibition of CHS staff being able to treat officers for purposes of aiding in a criminal prosecution. Not only does it disregard the health of the officer, but valuable forensic evidence may also be lost. If this becomes a rule the DLC must enforce, it will not only open a very significant avenue of litigation, but also a massive cost as the city must then duplicate CHS services for staff. Quite aside from the collective bargaining agreement with COBA, the city has a moral, and we would suggest a legal obligation to set up separate wards, both on and off Rikers Island, to treat correction officers who are injured at work, which occurs daily, as you know, as a result of active and inmate. This without regard to assumptions about criminal culpability or prospective prosecution of that inmate, as healthcare comes first, prosecution being a potential byproduct of inmate activity, i.e. as medical professionals are ignorant of whether injuries may lead to criminal culpability, negativity bias will lead medical professions to avoid helping correction officers rather than face repercussions for doing their job. Thus, the dual loyalty problem is extended and expanded. The other problem in the proposed rule, not as significant as this, also include the continued deprivation of information access to the frontline officers of mental health indicators, which could obviate such assaults as which occurred just yesterday. I also annexed an article highlighting the grave need for this information sharing with inquiry by the New York City Council, which after all is the body to which the board answers. That's actually my testimony. And just to be clear, it's important that when we have incidents in jail, that correction officers are not denied medical attention because of what this rule may impose on people from the Health and Hospital Corporation. The reality is if a New York City police officer, firefighter is injured, hurt in the line of duty or in responding to an emergency, when they go to the hospital, they're not denied because there might be a legal conflict with the perp or the person that they were involved in. And this is a concern of ours as far as the way we read this rule and the effects that we feel that this rule will have when it comes to correction officers. We don't want situations where the medical staff feel like they're going to be legally held accountable for something because they're actually providing a service. They have the Hippocratic Oath to service everybody. So that's basically our concern as far as the rule is concerned.
So, can we ask questions? So,
As long as I can answer it.
yeah, no. So you feel like there's in the rule that somewhere in those rules, it prevents CHS from attending to an officer that might get hurt in the line of duty?
Yes. We feel that might end up being the interpretation.
Okay.
And it's important that if that's not what it is, it's important that it's clear.
Got it.
And I just feel that if it's not clear to me, or if this is how I'm reading it,
Right.
and I represent the 11,000 correction officers, how is CHS or Health and Hospital reading it?
Yeah.
And we already have had incidents where medical staff did not want to treat correction officers involved in situations, so.
Thank
yes.
you. And we understand 2 officers were injured.
Yes.
We hope they're doing well. Do you have any update on them? I'm sorry for sidetracking.
No,
Are they
listen,
okay?
brother, for the last 24 hours, I've been, listen, yes. One, the officer assaulted by Munez, the inmate that attacked Guzman Jr.,
Yeah.
that officer has a fractured back and a dislocated shoulder. He's home, he's doing okay. The female officer yesterday at AMKC, attacked by the mentally ill inmate, she's doing okay. Thank God, believe it or not, Stanley,
Yeah.
for about 3 inmates and 2 officers,
Wow.
who were instrumental in.
Wow. Well, I'm glad they're okay, and our
Okay.
condolences, man. Thank
I just want to clarify something as well that wasn't really made super clear. The duty of loyalty, this conflict is a real one. It was written about by Homer Benton in an article that he published some years ago. The problem lies in servicing everyone in the
Right.
jail, and I'm pretty sure that the treatment in Health and Hospitals Corporation will be different if you go to an emergency than if you go to a clinic at Rikers Island. If they're not going to be using reports to potentially investigate and prosecute inmates, then we have a very serious problem here, and it's going to come to a head. I don't know if that was ever thought about, but I think Corp Counsel needs to know about that, and the Mayor's Office of Criminal Justice needs to think about it, because there might actually be a conflict here built into, which was unintended perhaps,
Right.
into the rule change. And the second thing, something we've called for forever, is information sharing, like in better best practice areas like in San Francisco, in Cook County, in LA, inmate symptoms that might like act out, like this inmate who choked an officer in the NKC, could it have been avoided with sharing some information? I don't know.
Right.
But for the longest time, we've had concern about getting better access to information.
Officers, DOC, and CHS.
At the officer level,
Yeah.
because I do understand
Operational.
there's some sharing at the upper levels, but that doesn't necessarily mean that anyone on the ground, so to speak, can take advantage of it. 43% of the inmates, 50% of whom are going to be back, according to a recent article that was annexed to what I'll send, they're not strangers to the system.
Right.
And something needs to be done to not just between CHS and DOC. I understand there's definitely institutional conflict there, but not necessarily between the staff who are medical and correctional officers. They get along they have, as far as I know, got along just fine.
Right.
I just want to make sure that continues and can even grow.
Got it.
I have a question about the clinical services for your members. It's a large operation. Seems to me there's a basis for having a clinical services directly for you. The joint use of the clinic areas, certainly in the larger facilities, creates problems for everybody.
Yes.
And is that, so do you have a proposal on that, or, is it work, for example, is the Horizon situation working better for you? I understand this, that theoretically there's an RN assigned to Horizon most of the time. That's what they tell me when I go there.
Well,
I don't know what's happening.
when Horizon opened, we had a few issues as far as the medical staff understanding that they have to provide
Right, I assumed you
service
were- if you were- if you were referencing that.
to the offices as well as the inmates. We don't have a proposal, but I've been doing this a long time, and I could stand here and give you a proposal. I mean, if they want, they can open up 2 separate clinics when things happen. They could have one clinic to see staff and correction officers, and they can have a clinic that will see the inmates. So, I mean, sometimes, Bobby, in some of the facilities, because the clinic is so small and we have a large incident, it's kind of hard to bring in
No,
the inmates
that's why I
and
think
the
for a large
officers. So,
facility,
I mean, as a proposal, that's something to think about. I'm not quite sure as far as the infrastructure and everything is concerned, or the space, or whether it can or cannot be done. In some places it can, in other places it might be a little difficult.
It seems to me that there are some situations, and I, structurally, I don't know how the Horizon thing worked, but
Right.
I know where it came from, and then I knew it was there, that having a dedicated,
At Horizon,
Yeah.
you were there when I was there.
yeah, we were there together.
We were there together, and there was a ruckus involving dozens
Mm-hmm.
of officers and youth. And it was clear to anybody who was looking at it, that the facility was not predisposed to be able to treat that scenario. And that scenario wasn't a rare scenario in the beginning. It was one of the many failings about Horizon being up and running before it was really ready. So I don't have a proposal. I'm
But
not
there's
an
an
engineer.
R-rated sign there now, right, from CHS to support DOC staff.
Yeah, right now, we're not having those issues.
Because there's a dedicated person.
I'm not sure, Bobby, if it's a dedicated person, but I do know that they actually see the correction officer. I'm supposed to be there later on today. I could actually
But
get
as far as
that
the
done,
rulemaking and the
Yeah.
sharing of
Yeah.
information, I'd be more than happy to continue that conversation,
Thank you.
because I do understand the privacy and confidentiality in mental health. But we have a superseding problem, which is half of the population of Rikers are coming back, and they all are MO, just like the inmate who assaulted the officer yesterday. And it could be that information sharing can nip in the bud, and I'm sure that Steve Martin, the monitor, would love to hear some ideas. Nip in the bud unnecessary incidents.
That
And-
incident
and just-
yesterday was in GP, or was it in?
It was
GP?
in ML. It was in 11 Mart, which, just to piggyback, and then I'll stop. This is the reality. When I went to San Francisco to visit the jail there, they did do information sharing with the correction officer. I can say for a fact that if the correction officer who was assaulted yesterday knew that this particular mentally ill inmate had already did 3 or more years for rape, I'm almost positive that she would not have even allow herself to be at any time alone with this particular person. So the information sharing that's done outside of New York is something that needs to be done here. When I went there and I visited the jails, the correction officers actually at the table while they're discussing treatment and things, and they also have different information available to them, even as triggers. They discuss with the correction officer, this will trigger this with this particular inmate because of this particular medication. And it's something that we can probably do here.
Yeah.
Okay?
Well, thank you.
Thank you. Thank you
very
very
much.
much.
Do we have anyone else?
Yeah, Dr. Martin.
Do we have anyone else? So, at this time, we don't have anyone else who wishes to testify. We will leave the hearing open at least until 10 a.m. And I should also say we have received written comments from the city's health and hospitals, and that will be included in the record, as will any additional comments written or received on our voicemail up through next Tuesday, June 25th.
Are our mics on? Mine.
There, at this time, there are no further members of the public here to testify, so we will be closing the public hearing. Just a reminder, you can still submit testimony via mail or email until next Tuesday, June 25th. Thank you very much.